Good morning, everybody, and welcome to one of two sessions of the second session of the second day of this year's annual Rapoport conference. My name is Barbara Harlow. I'm from the Department of English here at UT and have had the pleasure of chairing many sessions at these annual conferences, so I'm glad to be with you all again. Our session this morning is on global justice, inequality, and human rights. And we have three speakers this morning. Unfortunately, Charlotte Steinworth couldn't join us. But we're going to go in the order in which they appear on the program. And I'll introduce each of them now, and they'll speak in turn. We've asked them to keep to 15 slightly plus minutes, and I'll be a ruthless timekeeper, because we're particularly interested in following up on the discussions that have been emerging over the course of the last day and will continue through tomorrow. So our first speaker today will be Natalie Davidson, who is a PhD candidate at the Buchmann Faculty of Law at Tel Aviv University. She's also been a fellow at the Rapoport Center this year. And I'll ad-lib a little bit here. It's been a pleasure to be working with her. And maybe she'll give a plug for the Rapoport Center's Working Paper series, which we recommend to all of you. Natalie will be followed by Ali Malik, who is a PhD candidate at York University. And he will be, actually, Natalie will be speaking about the Alien Tort Statute litigation and transitional justice. Ali is going to be talking about structural violence and everyday resistance, looking towards a global socio-legal approach to human rights. And finally, Zinaida Miller, who is a postdoctoral fellow in global governance at the Institute for the Study of International Development at McGill University, is going to be talking about economic rights, crimes, and wrongs. So let's get started with Natalie.
Okay, I'm going to stand. Okay, well, hello, and thanks for joining our panel today. So contrary to the two other panelists here who, as I understand it, are going to give you very macro presentations of their topics, I'm going to tell you a story about one lawsuit today and use that story to ask questions about a recent trend in human rights activism of the past 2-3 decades, a trend which you may know as global justice or the movement for accountability or the fight against impunity, but a trend which I think can be usefully characterized as a remedial turn with respect to gross human rights abuses. When it comes to gross physical violence like torture, disappearance, execution, we are no longer content in the human rights community, and with good reason, with requesting from international human rights bodies a declaration that a human right has been violated, and getting a list of recommendations of what the state could do, should do to remedy those violations. Instead, we seek to obtain through international, regional courts, foreign domestic courts, orders, precise remedial orders that tell the state exactly what it needs to do, and that has developed into a whole case law with a state duty to prosecute, a state duty to compensate, or alternatively have these foreign domestic courts or international courts actually provide the remedy themselves, right? The International Criminal Court prosecuting perpetrators itself. So the question I want to ask through this lawsuit is whether in our push to obtain better transnational regulation and specification of remedies for gross abuses, we might not be losing something, and specifically whether we might not be removing too much decision-making power from the state, and in doing so, undermining the ability of societies in transition to address economic injustice. So the story I'm going to talk about is a lawsuit against Ferdinand Marcos, former president of the Philippines, who was ousted from power in 1986 after 14 years of martial law rule during which democratic institutions were shut down. Marcos and his family and cronies made a fortune off government coffers, and security forces violently repressed opposition. All the while, the government received solid economic, political, and military support from the United States. In 1986, Marcos was challenged by a peaceful people power revolution, and Reagan asked him to step down and flew him and 22 other members of his clique to Hawaii. So 1 month after his ouster from power, he was sued in U.S. federal courts in a number of lawsuits under the Alien Tort Statute. For those of you who aren't familiar with the ATS, as I'll refer to it now, it's a piece of federal legislation which was interpreted between 1980 and 2013 as providing a form of universal civil jurisdiction, meaning it allowed victims of gross human rights abuses to sue perpetrators in U.S. federal courts, even if there was no clear link between the case and the United States. One of these lawsuits was a class action filed on behalf of 10,000 victims of torture, disappearance, and execution. Marcos died in the course of the litigation and was replaced by his estate, represented by his wife, the famous Imelda of the 3,000 pairs of shoes, and his son, now a candidate for vice president in the upcoming elections in the Philippines. In 1992, he was found, or his estate was found responsible, and in 1994 and 95, the victims were awarded a total of approximately $2 billion in damages. And so that is usually where the story stops. In scholarly commentary, this lawsuit is applauded for promoting accountability and providing redress to victims, and this is generally the framework that has been adopted by human rights advocates and scholars when they analyze Alien Tort Statute litigation, or when they argue that other courts in Canada, England, and other countries should allow this kind of litigation. But talking about enforcing victim rights or holding perpetrators accountable is a highly individualized perspective. And there's been very little interest, let alone research, on what these lawsuits might actually mean for the very societies in which the abuses occurred. So that's what I tried to do in this study. I revisited Marcos, this landmark case, and examined its interaction, the interaction between this lawsuit and transitional justice debates and initiatives in the Philippines. So the Marcos case is a good case study for a number of reasons for understanding the domestic impact of ATS litigation. One of those reasons is that it's an extreme case, right? It's unusual, but it went very far in establishing liability toward a large group of victims. And there was actually a chance of enforcing the damage award because the estate, the Marcos estate, is estimated to have at least $5 billion in assets spread around the world. So this kind of extreme case activates many actors and mechanisms, and you can learn about the logic, the institutional logic of this kind of lawsuit from this kind of case more than a typical case. So what I found is that the ATS plaintiffs' attempts to enforce their damage award, their $2 billion damage award, came into direct conflict with the Republic of the Philippines' main transitional justice policy, which was one of economic redistribution. Upon the transition to democracy, the first thing President Cory Aquino did the day after she became president was to establish the Presidential Commission for Good Government, PCGG, the brochure of which you can see here, which was charged with recovering the billions of dollars of assets stolen by the Marcoses and their cronies and unraveling the whole economic structure of companies that had been nationalized under Marcos and handed out to his friends. As you can see from this brochure, this commission operates really within a discourse of good government. It's dealing with corruption, but it still tried to address really profound causes of economic inequality, because under a law enacted in 1987, all of the proceeds recovered by this commission are allocated to an ambitious program of land redistribution. allocating basically land to landless farmers and thereby trying to attack one of the main roots of economic inequality in the Philippines, as in many other former Spanish colonies. But every time the PCGG tried to attach Marcos assets around the world, whether financial assets or real estate in the United States or bank accounts in Switzerland, the class action lawyer representing the torture victims would show up with his judgment, his $2 billion judgment obtained in a Hawaii federal court, and argue that the assets should be used to satisfy the ATS judgment. And the Hawaii court, which managed the class action, issued many injunctions over the years that tried basically to help the plaintiffs enforce their judgment. So appellate courts around the world, including the U.S. Supreme Court in 2008, gave the Presidential Commission on Good Government and the Republic of the Philippines the upper hand in these legal battles with the torture victims, in part through legal doctrines protective of sovereignty, such as sovereign immunity or the active state doctrine. In decisions like this one from the U.S. Supreme Court that clearly recognize the important political and historical states for the Philippines of deciding what to do with that money and how to reconstruct after Marcos. But I think the decisions issued by the Hawaii District Court, which consistently gave preference to the plaintiffs, give an idea of what it would mean to go all the way with this kind of litigation and enforce the victims' rights. My point is not that torture victims should not receive compensation, but to remind us, as this former commissioner at the PCGG did here in an interview, that there are many types of victims, many types of injustice, and many ways for a country emerging from conflict or authoritarianism to address the past. Yet under the guise of rights enforcement, alien tort statute lawsuits pressure the state to prioritize corrective justice for gross physical abuses without giving any room, without acknowledging that there might be other approaches and other claims, without considering what the trade-offs might be with other claims competing for attention and resources. Now, ultimately, as I said, courts around the world ruled in favor of the Republic of the Philippines when it came to those assets through doctrines protective of sovereignty. So the victims' claims were mediated by domestic processes. As a result of their losses in court, the plaintiffs lobbied the Philippine Congress for the enactment of a compensation law, which they finally obtained in 2013, which allocates a much smaller amount of funds, $200 million, to compensation, and therefore the whole program of land redistribution was not affected. This law, this is just a brochure explaining the claims process under the law, just to show you, I'm not making this up. This law was originally conceived as a way to enforce the ATS judgment. In the original bills, victims who were not plaintiffs in the United States were excluded or were given a smaller portion of the funds. But following parliamentary debates, the law was expanded to include non-plaintiffs and to include other sorts of victims, such as victims of expropriation or sexual abuses. And the claims proceedings have ended. There was a short period to file, and over 45,000 claims have been filed. And it's not just with the numbers that, that new victims are appearing. There are new forms of victimhood that are being revealed. The ATS plaintiffs were largely urban folk, activists, politically organized activists in the left. And with these new claims, more peasants and more common folks who are involved in more common forms of resistance are having their stories told for the first time. And these stories are being told not just in the claims forms, but through all these new or pre-existing memory projects that are getting boosted by the claims proceedings. This is a picture of a poster I took in Baguio City, a large provincial town north of Manila, in a convention center where claimants could come and file their claims under the compensation law. And I saw how after people would go through the whole process and file their claims, members of NGOs and victim groups, and also the Human Rights Commission and other governmental groups involved in memory projects and educational projects would approach the victims, ask them if they'd like to have a drink, rest, and step aside, walk into a room and provide their video or oral testimony and tell their stories for a number of projects to be used in schools. So this compensation law, it's a direct product of the ATS lawsuit, but because of enforcement difficulties, the torture victim claims had to be mediated by domestic processes. That produced a richer compensation mechanism, and it also allowed the Republic of the Philippines to balance the claims of victims of physical violence with a policy of land redistribution. So in many ways, what I've just told is a happy story, right, to the extent that we can have a happy transitional justice story. But notice that the result, this happy end, was produced despite the efforts, right, against the efforts of the human rights lawyers to enforce the damage award, and ironically, thanks to legal doctrines protective of sovereignty. So the question is, what now? What does this mean from a policy perspective for us human rights lawyers? So in a sense, you can say, well, this is a story about ATS litigation. This is a story about universal civil jurisdiction, which is a human rights mechanism that has suffered many setbacks recently and can be seen sort of as it's out the door. But I think other remedial mechanisms devised at the international level are not so different. When the Inter-American Court of Human Rights orders states to prosecute all perpetrators of human rights abuses, ruling that alternative mechanisms such as truth commissions are insufficient responses, is it not directing the state to allocate huge financial and human resources to addressing the past through corrective and retributive justice without allowing any space to consider what the appropriate trade-offs might be with other claims and other policies competing for the same state resources? So, of course, scarcity is partially constructed, and the efforts to address different kinds of injustice, right, torture or economic injustice, are not a zero-sum game. But efforts of human rights advocates and these remedial mechanisms that have been developed at the international level, they take meaning, they operate in a world here and now where budgetary constraints and resource constraints are very, very real, in a world where sovereign debt, the rules relating to sovereign debt and foreign investment have not been overhauled yet. So for me, the challenge, and I'll end here, is first to recognize that these new remedial mechanisms we've developed at the international level have distributional implications. And second, once you've acknowledged that, the bigger challenge, and this is really very difficult, but it's to try to craft transnational human rights mechanisms that would pressure the state to listen to the claims of victims of physical abuse, but still require somehow those claims to be mediated and appropriated domestically and considered alongside competing claims, including economic redistribution claims. Thank you. I hope I haven't gone over.
Thanks, Natalie. We'll hear now from Malik.
Great. Thank you. Hello, everyone. My presentation today is concerned with how we think and conceptualize human rights. Admittedly, this work is in its nascent stages. My aim in this presentation is twofold. First, to broadly further advance what global socio-legal approaches to human rights might theoretically and methodologically look like by drawing upon insights from third world approaches to international law, or TWAIL, as well as anthropology and geography. So I'm kind of trying to push a research agenda here. And second, hoping that I have time, using those insights to briefly sketch the contours of how global socio-legal approaches to human rights might engage with an emergent form of rights concerning indigenous peoples, environmental law, and development, aptly named biocultural rights. So born out of 20th century American legal realism and as a reaction against legal positivism, socio-legal studies, or law and society research, has essentially recognized that laws and societies are mutually constitutive and interactive. It rejects formalist conceptions of law as emanating solely from the state and existing autonomously from the social and political realms. At its core, socio-legal studies is broadly construed to better understand the social, cultural, political, and economic context in which law operates in practice, be it in the past or present. Now, I argue that socio-legal studies must begin to account for not only the globalization of law, but also how global law has permeated states, cities, and ruralities. It must additionally account for how domestic laws are constitutively forged through global legal processes and how they travel across various circuits of political, economic, and cultural power. The dominant focus around states and international institutions requires an expanded conceptual lens to account for a growing number of increasingly powerful transnational actors. Global legal processes are deeply embedded in our everyday lives. Our varying abilities to cross borders, to breathe clean air, the kinds of food, water, and medicines we can access, and the cultures we enmesh ourselves in are all to some degree regulated by global law. Global law, by which I mean an assemblage of laws, actors, discourses, and other connections between domestic, international, and transnational law, then positions peoples and communities as its subjects, not just states or international institutions. A globalized world full of intertwined networks is a world full of globalized legal arenas. It is also a world of globalized injustice. Exploitation, whether in labor, natural resource extraction, development schemes, international trade and investment, or elsewhere, is produced and legitimated through international law. As such, this necessitates serious considerations of the ways in which power, and I mean power in a Foucauldian sense, operates and maneuvers throughout global law both overtly and covertly, and its encounters with marginalized peoples across the world. I argue that in assessing the structural injustices ingrained within international law, scholars must supplement their wide-ranging critiques of doctrine, institutions, and legal histories with the focus on the peoples and communities interpolated as the subjects of global law. In short, the top-down critique must be juxtaposed with the bottoms-up analysis. Eve Dearden Smith articulated the beginnings of what a global socio-legal approach to human rights might entail. It recognizes that legal systems rich with divergent social histories interact and mutate across multiple scales. Dearden Smith advocates for investigating law's counter-hegemonic potential, stating that a global legal socio-legal approach is essential in order to think through legal strategies that may help address the world's contemporary challenges, risks, and demands that are not bound within or contained by national jurisdictions. Echoing scholars such as Balakrishnan Rajagopal and Boaventura de Sousa Santos, she asks us to understand how the globalization of law affects not only the global elite, but the masses across classes and races. One does not have to hold an investment portfolio, drink Coca-Cola, or access the internet to be analytically and ethically relevant. A global socio-legal approach would then embrace a holistic framework identifying seemingly distinct yet interconnected sociocultural, political, and economic realms while complicating our modern and linear understandings of what law does. Global law and human rights must be approached without illusions that either are autonomous. They must be conceptualized as mutually constitutive among various scales. Legal processes at the subfederal level are increasingly impacted by global legal processes, and as Luis Eslava has illustrated in his recent study of international law and developments turned to the local in Bogota, international law shapes the daily life in and around the most local spaces. Global socio-legal approaches then must map the legal and social interconnections, disruptions, and flows of power between global, domestic, local, and non-state law without necessarily privileging one at the expense of other. Mapping global legal interconnections necessitates decentering and destabilizing of the nation-state without losing sight of its continued importance. We must interrogate the counter-hegemonic potential and the limits of state sovereignty. Rather than bemoaning the loss of state sovereignty under conditions of neoliberal regulatory restructuring, global socio-legal approaches might expand our lens of relevant actors who are now involved in law and policymaking, such as NGOs, multilateral institutions, regional blocs, private actors, development banks, and transnational social movements. Where do these emerging actors derive power from? What sorts of stories and sensibilities do they tell about their roles in globalized legal orders? And how does that affect their policymaking efforts? And how do they come to conceive of their encounters with the active subject recipients of their law and policymaking? Global socio-legal approaches, while not losing sight of the continued importance of the nation-state, must connect the decentering of the nation-state with long-standing tendencies to depoliticize transnational legal arenas. So, if what I've commented on thus far resembles some kind of turn to the transnational, that turn does not relegate the local to the background. Rather, it calls for a refocusing on localities and the multitude of elements that construct local places. Rather than simply assume that conditions of neoliberal globalization have swallowed the local, we must be attuned to how place is being repoliticized and articulated as a catalyst for political action. Following anthropologist Arturo Escobar, place-based struggles might be seen as a multi-scale, network-oriented subaltern strategy of localization. A holistic reading of place in relation to global law, human rights, and social movements would recognize that place, body, and the environment integrate with each other. That places gather things, thoughts, and memories in particular configurations. And that place, more an event than a thing, is characterized by openness rather than a unitary self-identity. How might engaging with global law and circuits of capital from the side of the local affect our understanding of international law's production of structural inequalities? How might we come to methodologically engage local places in connection to globally scaled, deterritorialized legal problems presented by environmental destruction, for example? Now, one element of this analysis takes seriously historical and ongoing legacies of imperialism and colonialism in international law. Twale engages in deeply historical readings of how international law has and continues to structure conditions of intervention, domination, and underdevelopment in the Third World. Global socio-legal approaches might put Twale into conversation with political ecologists and critical geographers in recognizing that places are not fixed, permanent, unconstructed, or unconnected, but rather are contingent, dynamic, and are shaped by global legal processes. Among some critical cultural geographers, the notion of place is viewed as a resistance to globalization from above. Now, global socio-legal approaches would not romanticize or essentialize place, but engage with how it is being deployed and altered by various actors in both making successful human rights claims and perpetuating injustices. Now, there is a growing turn within Twale, and I think and a lot of critical scholarship generally, to turn to the everyday life of international law. Many are calling for a methodological turn towards legal ethnography. Global socio-legal approaches, I think, might follow suit, enabling us to engage with subjects historically either overlooked or excluded by international law, while demystifying the international as a realm of expertise. Although we must be cognizant of ethnography's sordid history, and I suggest holding on closely to Linda Smith's wonderful book, Decolonizing Methodologies, when trying to think about how we can perform different types of methods. Numerous scholars also emphasize the strategic role that law can play in challenging persistent colonial hegemonies in post-colonial states, as well as the potential for alternative histories of human rights, which foreground third world experiences and cultures. Structural critique is crucial and necessary. However, holding this position must be complemented by a bottoms-up analysis, which may provide us with insights of emergent modes of precarity and also forms of daily resistance that draw upon the co-constitution of local epistemologies and transnational alliances.
You got 2 minutes.
Oh, wow, okay. So I'll skip through a lot of what I was going to say and get to the biocultural rights. Now, biocultural rights were born out of the Nagoya Protocol and pioneered by Kabir Babakati, who is the current head of the Christensen Fund. They're loosely predicated on the nature-culture nexus and an ethic of environmental stewardship. Biocultural rights affirm the bond between indigenous, tribal, and other communities with their land, together with the floral, faunal, and other resources in and on the land. These rights link aspects of endogenous and post-development commons movements and collective indigenous peoples' rights. They are posed as a counter to technocratic development. They place decision-making authority in the hands of local communities, and their indigenous peoples are fundamentally seen as stewards of the environment. The most notable example was found in Peru with the Quechua communities who set up a potato park, which functions as an in situ gene bank in a biocultural territory to conserve the traditional potato varieties. So just thinking very quickly about how biocultural rights, or how global socio-legal approaches would approach biocultural rights, they challenge us to expand our epistemic parameters of what rights can be. They challenge the nature-culture bifurcation and the mastery of nature rooted in Enlightenment rationalities. However, it would also be subject to critique. We must take seriously the potential for biocultural rights to recreate indigenous peoples as environmental stewards and the noble savage. There's the pitfall of essentialism is very much there in constructing that social imaginary. What happens, for example, if and when an indigenous community is found engaging in environmental practices which are deemed harmful to the environment? Are they automatically excluded from biocultural rights? Might policymakers find ways to shepherd these groups into certain conservation practices? Ultimately executing biocultural rights as forms of governmentality operating under market logics. Even in local struggles, there are winners and losers. Some communities might benefit at the expense of others. How will these sorts of conflicts be addressed, and on what kinds of analyses? So I'd just like to close by saying that the work of human rights is very messy, and critical international legal scholars should embrace the messiness, not be afraid of it. Thank you.
Well, things are indeed getting messier and messier, so we're going to continue with the paper by Zinaida Miller, and then hopefully we can open this up to further discussion. Thanks.
So first of all, thank you to Karen and Billy and the rest of the Rapoport Center for putting together this really fantastic conference. It's a real pleasure to be here. In 2003, at a press conference following the final completion of the South African Truth and Reconciliation Commission report, the Commission's chair and one of its chief architects, Archbishop Desmond Tutu, reportedly asked, "Can you explain how a black person wakes up in a squalid ghetto today, almost 10 years after freedom? Then he goes to work, which is still largely white and palatial homes, and at the end of the day, he goes back to squalor? I don't know why these people don't just say, to hell with peace, to hell with Tutu and the Truth Commission." Tutu's statement reflected a frustration seemingly less with the Truth Commission process itself than with the failures of the post-apartheid government to alter the fundamentally unequal economic reality of the new South Africa. Another 13 years have passed, and South Africa's continuing inequality, among other things, has sparked many protests in recent months and years. And for those who championed the country's transition as a miraculous turn toward peace and reconciliation and away from violence and division, the question remains: how should we understand the relationship between the fundamental transformation seemingly offered by transition and the preservation of inequality that so often follows its ostensible completion? In his 2011 critique of human rights after evil, Robert Meister argues, quote, "The now established techniques of transitional justice aim to convince beneficiaries that their ongoing advantages will not be denounced as continuations or revivals of past injustice." For Meister, it is neither accident nor practical limitation that makes transitional justice resistant to questions of inequality and redistribution, but rather the counter-revolutionary nature of the project itself, which operates through a language of transformation that masks continuities in inequality. As he writes, quote, "The fin de siècle idea of justice as reconciliation was itself a supersession of the revolutionary model of justice as permanent struggle on behalf of unreconciled victims of past injustice." Over the past decade, transitional justice scholars and practitioners have increasingly called for greater attention to a broad set of economic concerns, from corruption to inequality to structural violence to economic rights. What was once an external critique of the field has become a mainstream preoccupation, to the degree that the more marginal, if not critical, argument has actually become one against the inclusion of economic issues in transitional justice work. More and more arguments are made for the justiciability of economic rights in international criminal law, for the pursuit of anti-corruption charges by new regimes, for partnerships between transitional justice and development efforts, and for the foregrounding of histories of exclusion that were once relegated to context. The institutions have been somewhat slower to embrace the inclusion of such questions in their purview, but truth commissions in places like Liberia and legislation recently in Tunisia have devoted more and more energy to economic rights and crimes. In response, other scholars have countered that the already overburdened field of transitional justice cannot afford such a broad mandate, and that new post-conflict regimes cannot deal with the destabilizing effects of structural change. I will argue today that these debates have been marked by two deficits. First, they've tended to conflate a spectrum of critiques about inequality, distribution, corruption, and rights into a singular holistic category without internal contradiction that can be answered with common techniques. Second, these debates, largely premised on solving problems in the field, still avoid the question with which I began. How precisely do transformation and preservation operate together through the language and practice of transition, law, and justice? So my talk today has two parts. I'll briefly lay out the debates over the place of economic concerns in transitional justice work, suggesting that the debates have been in many ways thin because they have contemplated discrete problems and targeted responses rather than looking at structural issues and inequality. In the second part of my talk, I want to discuss three frames that I think shape the ways in which scholars and advocates working in the transitional justice and international criminal law fields tend to view the relationship between inequality and their work. The first is the temporality of transition, the second is the politics of victim representation, and the third is the deployment of expertise. And I want to argue that each of these frames tends to foreground ideas of rupture while masking continuities of subordination, hierarchy, and exploitation. And in making this claim, I'm not trying to argue that there aren't, in fact, very real and critical changes that do occur in moments of regime change and at the conclusion of conflict. But I want to highlight the ways in which change and continuity function together through a particular discourse of transformation. So first, as a field, transitional justice evolved out of a pragmatic concern with how to address violence and atrocity by past regimes, coupled with a faith initially in theories of transition that held that democracy could be catalyzed by elite pacts rather than waiting for gradual societal modernization. The field was a product of particular objectives that preoccupied mainly political scientists, lawyers, and human rights activists in the 1970s and 80s, how to achieve justice for victims and how to strengthen new democracies. The answers to both were taken to revolve around a specific and now thoroughly familiar set of institutions, trials and truth commissions, reparations and administrative purges, and constitutional reform or replacement. And these mechanisms were embedded in a set of debates that almost entirely excluded questions of distribution, economy, social and economic rights, or colonial legacies, although the enactment of private property rights and discussion around that was certainly part of the preoccupation. By the mid-2000s, these lacunae were noted and critiqued. Critics argued that ignoring questions of economy undermined the project of peace because inattention to root causes of conflict could reignite violence, or that they threatened the interests of victims and created a hierarchy of rights. So in the literature and to some extent in the institutions, three main responses to these critiques emerged: anti-corruption efforts, increased attention to socially economic rights, and a kind of turn to development or a call for partnering with development. And so the first set, anti-corruption efforts, range from asset recovery, and of course Natalie's paper got to the complications of that, to most recently in Tunisia, there has been a kind of ongoing interesting political football game going on over the relationship between economic amnesty and corruption attempts and sort of how those have become part of the post-revolutionary struggle. The second move was scholarship and also, to some extent, in the institutions, trying to demonstrate the ways in which, in fact, socioeconomic rights are justiciable, have become or already were parts of transitional justice or international criminal law, and a number of truth commissions have been much more attentive to citing various violations of economic rights. And then there were a number of scholars who in recent years have turned toward the idea that the sort of increasing application of transitional justice to post-conflict and very poor states and the turn of development toward rights and governance meant that there was a natural convergence between the two fields. Noteworthy is that none of these necessarily address inequality, although arguably any of them might offer steps along the path. And the scholarship has had a worrying, although perhaps unsurprising, tendency to conflate both concern and response in a way that makes it appear that addressing a particular economic crime or harm will in turn have some bearing on fundamental issues of historical conflict-related or post-conflict inequalities of income, opportunity, access, and distribution. So turning to the second part of my talk, transitional justice has been characterized by what Robert Cox once called problem-solving theory. And so doctrinal and institutional discussions of best practices and tools to address particular harms tend to dominate the literature. In beginning to think about the relevance of inequality to transitional justice and vice versa, I argue that three frames structure the debates over economy and justice: temporality, victimhood, and expertise. These frames, each in their own way and together, signal rupture and a break with the past, thereby masking or backgrounding lines of continuity, including unequal distributions of power, land, resources, and opportunity. So first, thinking inequality in terms of transitional justice forces us to frame questions temporally. In the problem-solving mode, questions about time revolve either around sequencing or the need for a transitional regime to avoid destabilizing moves or to embrace the opportunity for complete change. These modes of temporal thinking give rise to progress narratives of transition while obfuscating often the relational nature of harms committed prior to and during conflict. The rupture of past and present created by the transition, such as by focusing on a post-racial, post-conflict, or post-authoritarian state and society, relegates particular harms to history while inevitably preserving the continuity of others under the heading of stability. One of those continuities is often, albeit not always, the class of beneficiaries of past injustice. The transition becomes, in this sense, a preservation of privilege, or at least a reluctance to question its origins. In his recent book, Ta-Nehisi Coates probes this amnesiac impulse in the United States, a place far from transitional in the minds of most who advocate the particular justice of transition. Coates writes, quote, "This is the foundation of the American dream. Its adherents must not just believe in it, but believe that it is just, believe that their possession of the dream is the natural result of grit, honor, and good works. There is some passing acknowledgement of the bad old days, which, by the way, were not so bad as to have any ongoing effect on our present. The mettle that it takes to look away from the horror of our prison system, from police forces transformed into armies, from the long war against the black body, is not forged overnight. This is the practiced habit of jabbing out one's eyes and forgetting the work of one's hands. To acknowledge these horrors means turning away from the brightly rendered version of your country as it has always declared itself and turning towards something murkier and unknown. The discourse of transformation that accompanies moments of political transition is equally an act of preservation, a way to entrench inequality through a process of amnesia that claims the mantle of memory. Remember acts of physical violation, but not the structures that beget them. Name as victims a particular group that suffered brutal violence and let fade into the background those who went dispossessed and displaced, or those enriched from that dispossession. Understand transition as the aftermath of revolution rather than potentially the counter-revolution. In her critique of the root causes discourse in human rights, Susan Marks suggests that the very claim to be getting at actual causes of human rights violations, even when those efforts genuinely bring economic questions to the surface, often masks the background structures. She cites a Human Rights Council meeting on the 2010 earthquake in Haiti, which admirably recognized poverty and discrimination as the reasons for the catastrophic impact of the earthquake. What the Council did not discuss, however, was the history of U.S. and international economic and political interventions that had enriched a small domestic elite and a series of foreign interests at the cost of public infrastructure, health services, and local industry. In this sense, both Marx and Coates prompt us to rethink the ways in which a particular presentation of time, causation, or progress naturalizes certain relationships of inequality while genuinely transforming others. The second frame that shapes the relationship between inequality and transitional justice by promoting ideas of change while masking continuity is that of victim representation. In both transitional justice and international criminal law, the figure of the victim plays a crucial justificatory role. The victim has been mobilized on behalf of opposing claims. On the one hand, critics have made empirical claims that victims prefer material relief and assistance to punishment for even atrocious crimes. On the other, the ICC's Office of the Prosecutor, among others, has argued that victims seek justice above all, a justice defined specifically as the prosecution of perpetrators. In each case, the victim is invoked as a defense for a particular political position and is a priori defined by the statement itself. Moreover, as Meister and Mahmoud Mamdani have both argued, the victim-perpetrator dyad excludes by definition a third figure, the beneficiary. In other words, the victim exists in relationship to an identifiable perpetrator, but as Coates reminds us, the individual states or groups that benefit from an unequal regime and are most likely to survive the transition with their privileges intact remain largely invisible. The third frame is that of expertise, which in turn raises questions about the distribution of knowledge, whether among apparently distinct technical areas or between North and South. As Joel Maggiri and others have discussed, if the economic problems of transition are defined abstractly as ones of hunger, insufficient water supply, or poor service delivery, then technical, legal, and economic expertise can seem the opposite solution. In contrast, if the problem is diagnosed politically as the continuation of racial and class inequality and uneven distribution of resources, then more far-reaching or different solutions might become necessary. In this sense, the figure of the expert and that of the victim function together. The victim is an individual or even a group in need of a particular service or good to be provided by the expert or policymaker. When the debate over expertise turns into one about the proper place of lawyers in prosecuting international crimes, humanitarian aid workers in delivering aid, and development agencies in determining the structure of the economy, the deep imbrication of law and distribution recedes. In fact, of course, the rule of law, based in transitional context on both the protection of private property rights and the pursuit of criminal prosecutions, plays a critical role in securing development aid and investment for post-conflict regimes. The unspoken assumption that a new regime's law will advance the social good demanded by those dispossessed in the past obscures the role that law may play in preserving inequality rather than challenging it. In addition, the manner in which transitional justice scholars and practitioners sometimes pursue economic questions can reinforce a problematic dichotomy between transnational expertise and limited accountability. On the one hand, corporations or rulers that have enriched themselves within their own national borders may at times be prosecuted or pursued through a truth commission, but far fewer mechanisms, as we know, exist for the pursuit internationally of multinational corporations or foreign governments that may equally have been enriched in these processes. On the other hand, the field of justice has come to be defined by the transnational export of international expertise. In this sense, justice seems to travel transnationally in expertise, while accountability then remains within national borders in some cases.
I have a whole range of choices.
I was waiting to see which one it was going to be. One might legitimately ask why those of us worried about inequality should concern ourselves with what is arguably a narrow subfield of human rights or post-conflict reconstruction. At best, it might seem that transitional justice is merely a holdover from an earlier era in which democratization seemed the inevitable outcome of political change. If one is concerned with inequality, it seems unlikely that we will find any useful answers among a bunch of lawyers and political scientists arguing over narrow questions of international criminal law or stages of regime change. If, however, we think about the categories of transition or post-conflict as part of the contemporary vernacular for redescribing distinctions between civilized and uncivilized or developed and underdeveloped, then the definition and practice of law and justice according to these categories becomes increasingly critical. The notion of transitional justice sprang at its origins from the idea that there was some special version of law required for transitioning states, a law for atrocity and authoritarianism, a law to help transform society. At the beginning, those laws were not necessarily uniform, although they were already part of a theoretical project that attempted to differentiate transitioning states from others. When transitional justice became a global enterprise, it did so as part of a larger project bent on reconstructing both states and societies in a particular political, legal, and economic image, and to do so as subjects of international intervention, financing, and expertise. To return to Coates' idea of America as a place built upon racial and economic inequalities, naturalized through the forgetting or minimizing of a particular past, we can see the power of the transitional scaffolding. Transition operates both as a lens to understand historical, legal, and political legacy and change, and as a categorizing impulse that makes it unthinkable for many in various international justice and policy circles to understand the U.S. as a transitional or post-conflict state. Institutions of transitional justice operate in the space between transformation and continuity, speaking and practicing fundamental change in some realms while preserving and protecting privilege in others. Those dueling projects of conservation and renovation are produced by a combination of international and domestic law, funds, ideas, agendas, and politics. And I'll just finish briefly with a quote from a Croatian writer, Dubravko Grecic, who wrote, "In the name of the present, a war was waged for the past. In the name of the future, a war against the present. In the name of a new future, the war devoured the future. Warriors, the masters of oblivion, the destroyers of the old state and builders of new ones, used every possible strategic method to impose a collective amnesia. The self-proclaimed masters of life and death set up the coordinates of right and wrong, black and white, true and false." Transitional justice has always sought to fight oblivion and amnesia, sometimes by punishing those self-proclaimed masters of life and death, sometimes by giving victims a new future, sometimes by retelling the history of what went before. The more that battle comes to rely on a specific fight on behalf of a particular group and against a narrow set of harms, the more tempting it becomes for those who wage peace to set up new coordinates of true and false or right and wrong. Reconsidering the process of transition and the project of justice in relation to the reproduction of inequality, however, suggests the need to rethink how those coordinates come about, who pays for their institutionalization, what effects they have, and who and what in the end they address or neglect. Thank you.
thanks everybody for these, what I think are really quite provocative papers, and are especially challenging, if you will, in their revisiting the erstwhile celebrations of transitions to justice via the unresolved economic distributive issues. I think, for example, of the reparations component of the South Africa's TRC, which has gone nowhere. And I think it's particularly helpful, these papers, in thinking about the relationship between inequality and human rights. And I think every bit as problematic as the terms we discussed yesterday, too, of inequality and human rights, is the and. And I often raise this with my students in my literature and social justice class. The real problem there is the and. Is the and a conjunction that they go together, or is it a divider? We have on the one hand, on the other hand. And I think that these three papers give us a really useful opportunity for thinking about that. And we do have time to think about it together, thanks to the cooperation of all three panelists. I'm going to hold my questions, because I have noted many of them, to give you all an opportunity to get the discussion started. And we could either take questions individually, or so we have microphones circulating, or why don't we start taking them one at a time, and then as we move along, we can begin taking them in clusters, okay? It looks like there's a question right here.
Hello. I just have a quick question for Natalie. I accept your thesis. The conclusion sounds accurate and correct. I'm curious, though, from the other perspective, from the PCGG perspective, they were going purely for a land redistribution. That was the rights that they were trying to promote, is land rights. And so in a sense, they were missing out on a lot of the rights violations that occurred. So couldn't it also be said, by having this victim-based approach from the ATS, that they encourage the PCGG to consider other victims, other means of victimhood? So in a sense, it was a positive result of having that pressure put on them to not just go from not just to follow their original plan. So.
Can you go ahead and answer? Or yeah. Okay. Thank you. Yeah. So just a little clarification. So the PCGG, by law, it's established to do a certain thing. It was established to recover assets, and then those funds were going to land redistribution. So it wasn't part of its task to address human rights abuses. But if I just replace in your question the word PCGG with the Philippine Republic, then yes, absolutely. For years, the claims of the victims of torture and the family members of those who had been disappeared and executed were really ignored. There had been a Human Rights Commission established in the Philippines also at the same time as the PCGG, but it lacked political backing. Many of the people who were in power, who led the military and the police and repressive forces and security forces in the Philippines, stayed on in the government. And actually, the president who came after Cory Aquino, Ramos, was the head of the Philippine Constabulary, which was one of the bodies most responsible for torture under Marcos. So those claims had been ignored. And yes, the ATS lawsuit and this huge amount of money, which really focuses the mind, $2 billion plus interest, it's grown to a lot more since. And this very real threat of enforcement forced the Philippine government and the Philippine Congress to take these claims seriously, along with other, there are other local circumstances, of course. It's not a coincidence that the law was finally enacted under the presidency of President Aquino, who was much, the son of Cory Aquino, who's much more open to the victims' claims, and also the Marcoses were rebuilding themselves politically, so they didn't oppose this. All this to say, yes, the ATS lawsuit provided a lot of pressure and was good, and so that's precisely my question now: is how do you recreate that? How do you recreate this this pressure? but without going all the way, without giving the victims so much power that they can actually attach all the assets they want, and that their individualized perspective and their sense of entitlement, which you can argue is justified in many ways, but without this affecting the national resources just because they have gone out to a foreign court. So in this case, legal doctrines protective of sovereignty provided that sort of buffer. So there was pressure, but it had to be dealt with. It had to be implemented through a domestic process.
Thanks. I think maybe we can hear.
Sorry.
We can begin collecting some more questions now that address the issues that we've heard discussed. Are there any? I didn't mean to cut you off. But
No, that's I'm done.
I have a more generalized question about, just the whole idea of this kind of rules and law-based formal legal apparatus in terms of resolving disputes and a kind of a spontaneous indigenous response to issues of social equity. I mean, like here in Austin, there's, after Sweat v. Painter was decided, they started, even before Brown versus Board of Education, they started desegregating things in Austin. They thought Jim Crow was over. And there wasn't litigation around it, even though Jim Crow wasn't over. They just started doing it. It was a spontaneous thing. Now, in the Middle East, this is my question. In the Middle East process, peace process and everything, you have all of these international organizations. You have the American government that's involved. You have the push for a two-state solution. You have all of this stuff that is really a debate about legal rights. And then at the same time, you do have movement inside Israel. I mean, all the hospitals, essentially, they take care of Arabs and Jews. You have a small movement of schools there that has Jews and Arabs in them. You have a hospital in the Western Galilee that, Syrian people that were injured in the war, they're brought into that hospital to be treated. How do you marshal? If you have these international organizations and this legal debate and everything, it becomes politicized and abstract. How do you marshal people on the ground in spontaneous movements for fairness to get them to transform a society? Isn't that a better way to do it?
I think this is a question that is relevant to all of our panelists. So perhaps we could take them in turn, given that Ali was also talking about everyday resistance and the question of sovereignty and litigation and the ATS, as well as possible eventual transitions to justice. So maybe we could just start. I think it's always a good idea to move from right to left. So from my perspective, we can start with Ali. This is only in terms of the seating arrangement, mind you. I think.
Well, I think that's an incredibly big and that's a question that really nobody has been able to figure out just yet. So, I mean, my own perspective is, I guess I'm less interested in trying to figure out how to marshal people to do certain things, but rather understanding the conditions around why people do those things to begin with, and who's doing the marshaling, to what ends. I don't necessarily, I just don't conceive of these issues. How do we get people to do things? So I don't know. That's just a really big question, and yeah.
Okay. Well, I think, for example, in the Israel-Palestine context you mentioned, I do see the goal as trying to marshal people to do things, specific things in that context. And just very briefly, obviously, I don't have a solution. I don't think anyone has. But I would say you get people to do things by being convincing, providing convincing arguments and incentives. And the question is the language of international human rights a convincing language right now for those you're trying to get to do certain things, i.e. Israeli population and their government. And my personal opinion is no. I think it's not a very convincing language right now for a number of reasons. And there are other languages, I think, that can be explored. And maybe religious languages have a chance, or maybe the language of inequality has a better chance of challenging this particular government, for example. So it's very context-based, depending on the place, I think, also.
Yeah, I mean, I think I'd pick up on that, too, and say that it's contextual and it's strategic. So if one is thinking in that kind of specific level terms about a particular struggle and one has a particular position about what is to be achieved, then there are a number of different levers that you can pull, right? And you're going to pull them at different times. But I think the question is how one assesses in that strategic mode what the different effects are going to be. So, for the Palestinians is the turn, what's been called the turn to internationalization, right? So the move to, statehood, the ICC, a series of, claims that are made kind of on the international stage, as it were. Is that strategically useful for what the particular leadership wants, or will it have other maleffects that will outweigh those? I mean, there's a, so I think, again, there's not, I mean, as my colleagues are saying, I think there's not a universal question to that, but I think you can play out to a certain extent, not completely, of course, but you can play out contextually and analytically as a person with an idea of what you want to get done with those ideas about local change or a more global kind of strategy, how you want to think about that. I could say more about that, but I'm not going to.
Maybe I could take advantage of my position here to also begin to respond to that question, and maybe to think a little bit about ATS cases, because Alien Tort Statute cases are often symptomatic or evidence of an everyday resistance. And particularly with regard to the Middle East, I think of the ATS case of Corey et al. V. Caterpillar, where the family of Rachel Corey and other victims of Israeli house demolitions and repressions in whether in Jenin or in Gaza. So Corey et al. Brought a case against Caterpillar, who makes all the bulldozers you see tearing up the campus around you, for aiding and abetting, for complicity, that is, in the commission of crimes. And the case was brought by the Center for Constitutional Rights, and I was thinking about this when you were describing the Marcos case. And even though everybody knew they weren't going to win, there's also, because there's the question of policy.
Political question, Doctor.
But CCR made a case for bringing that case, even though they knew it was what they called frivolous. And so it had another agenda than just winning a case against Caterpillar. It put Rachel Corey's case and her situation on a lot of different agendas. And so I think also, as another language besides human rights, litigation, everyday resistance, etc., of the BDS movement, the boycott, divestment, sanctions movement, which also involves Caterpillar and so on. And thinking back to South Africa, the effectiveness of the sanctions movement, the boycott, divestment, sanctions movement against South Africa. So I think it is worth thinking about the various languages, arenas, and realms in which one can mobilize around the "and" in the inequality and human rights. Sorry, I hope I didn't abuse my time here, but we do have another question waiting back there.
Hi, my question is for Zinaida. I understood the critique about transitional justice and how temporarily victimhood and expertise masquerade real change or significant change or even the overcoming of inequality. It seems like you're pointing towards a more revolutionary direction. So could you articulate more on what the proposed would be, especially in the context of racial inequality and overcoming the legacy of slavery?
Well, sure. So for me right now, I'm still trying to untangle the relationship between the kind of the preservation move and the change move. So I don't want to suggest that there is no change, or that, you know, in these moments we're not talking about significant alterations in a series of aspects of states and societies that we commonly think of as transitional or post-conflict. And one of my sort of trying to piece this through in terms of how it works is to think about how those function together, right? That there is very real change and there is very real preservation. And I think the piece of that I'm struggling with, and I think we're seeing very evident at this conference that keeps coming up over, and it's about the and, right? Which is, you know, I have worked on transitional justice for a long time. I am very concerned about inequality. I think that there's a relationship in terms of how those, you know, perpetuate to some extent. I also question whether it's a tool that can be used or should be thought about in these realms, or whether it's, you know, it's sort of just creating the scaffolding to, you know, to see change and not to see the lack of change. So, I mean, I don't, which is a very verbose way of saying I don't have an answer to the kind of normative question of what the revolution would be, nor am I necessarily saying that the revolution is a good thing. And I think, you know, so in Tunisia, which I'm by far not an expert about, and I'm just starting to look into, but one of the things that I think is interesting is that many of those who sort of were pushing for, you know, the revolutionary side are the ones that are still pushing for the transitional justice process, because they see it as kind of, you know, the justice project, right, that was still part of revolutionary change. So, which, you know, is an interesting kind of question about whether it can still be part of that. So, you know, the kind of intersection of where the economic inequality and the racial inequality and how those can function together and be changed over the long term, you know, it is a time question, it's a reparation question, it's whether we should think redistribution, right, in terms of something like land and not in terms of just victim identification. But, you know, I'm exactly still trying to unpack that question. So if you have ideas, I welcome them.
Okay, I think Vasuki had her hand raised, and then Richard.
Precisely on that topic, that transitional justice at one time did a lot, in terms of the relationship between inequality and transitional justice, in its heyday, as it were, in the 90s, early 2000s, transitional justice did a lot of work, did a lot of regressive work, shifting the conversation away from inequality and economic justice issues. When it had in the 2-2 kind of era, right? When it had, in some sense, when it was a vehicle for liberal virtue. Today, it's no longer that. Today, even its biggest advocates are all jaded and ironic, and you know how they talk about. None of them actually even can sell trans justice in a straight face, saying it's going to be the dawn of a new era, and therefore it does, I would argue, less work, maybe. I mean, I don't know what you think. Less work in terms of engendering inequality as well. So in South Africa, arguably one can make a very strong case, I think, that it captured the political imagination in a way that detracted from structural change and other kinds of policies. The difference between South Africa and Tunisia is that in Tunisia, now it's the biggest labor unions that are advocates of transitional justice, and they are using transitional justice as a way to keep the structural change issues on the front burner, as it were, and ensure that there's attention to that. So that even as transitional justice has become more mainstreamed and more bureaucratized and so on, that it does less, it's less able to be marshaled to suppress structural change. And now, it depends on it's just context by context, that the discipline itself is just now got mainstreamed into the human rights bureaucracy, the post-conflict bureaucracy, and because it's, that's, so anyway.
Yeah, I think that's right, and I think that, I think it's right that it's become more context specific and less sort of, it's more of an industry, and yet oddly is playing out, in some ways in maybe less uniform ways. I think as part of our way of thinking about places, I think a lot of the force of sort of I wouldn't underestimate the sort of ongoing idea about how we think about time in these places and how we think about sort of stages of change and which change happens at which moment and which actors are part of that. And I think transitional justice, as exactly part of now the human rights bureaucracy and also the sort of post-conflict reconstruction industry, which intimately, I think that analytic frame is not gone would be an idea about it, right? That even though and in fact because as it's become sort of more and more of this global enterprise, and on some level, I mean, I think now this paper is also interesting because of that question, right, of the conflict between what happens in the kind of, it's not just domestic versus international, right, but the different groups pushing, say, within Tunisia and how they're going to mobilize different international actors in that way. So I think there are ongoing legacies of that enterprise that are important to assess, even if some of the global conversation, has kind of moved more in the direction of, say, debt and other things that we've been talking about over the last couple of days.
Okay, thanks. Yes.
My question really follows on the last two, and it asks about the degree to which the transitional justice context is affected by perceptions of dangers of regression. To what degree, in other words, is the perception that there needs to be in this transitional context a compromise with the past in order to safeguard the move away from authoritarianism? I think this was particularly true in the Chilean case, where there was power was not, it's not a revolutionary situation where power is altogether shifted from one part of the social context to another, but rather it's a situation of a redistribution of power, where negotiation between the past and the present takes place, but also, I suspect, that perception is manipulated to resist the structural agenda, and saying this is as much as we can safely do, which would be the conservative continuity emphasizing position, and those are the people that control the procedures of transitional justice. I don't know if you'd like to comment on any of that.
I think this is another one of those questions that we could hear from all of our panelists on. And I was thinking about very much the same thing. In South Africa, for example, a lot of critics of the post-TRC dispensation refer to those dangers of regression as a deep state. In other words, the same state that ran it before is still running it now, just deeply and more covertly. But I think the issue of structural violence that you were talking about, who are the emergent actors, and the things that, so perhaps if we could again move from right to left, and
sure.
See if you have anything to.
Yeah, I mean, I think when I think about that question, I think it really is important to think about the emergent actors. Who else is playing a role in this? I mean, the state today isn't solely the sole decision-making body, I think, even in transitional justice issues, which I don't know very much about. But I can only assume that NGOs, both local and domestic and international ones, are playing a significant policy-making role here. I wonder how it's tied to different development agendas, to different development banks and different types of funding, between what's happening and what kind of benchmarks need to be met in terms of, I guess, performing that transition. So, yeah, I guess I really think that we need to broaden, our understanding of, even within these issues, of who's playing what kind of role and why and how and where. So.
Yeah, I think I would say, transitional justice as a field was born on this idea that you have to make a compromise. Well, that's how it was at first, right? In the 90s in particular, there was this idea of compromise, and that's what enabled I think that was the theory behind the Truth and Reconciliation Commission in South Africa. Now, I would say there's an absolutism in the sense that you can't make any compromises on the issue of physical violence, right? You have to address it, and the rest, redistribution, et cetera, is not perceived to be part of the transitional justice conversation generally. I mean, this is very schematic, but following this idea of where the compromise is. But I would just like to add that I don't think these are just perceptions. I mean, I wonder if there isn't really a structural inability in this framework of transitional justice and human rights to account more for economic issues, because economic issues and unequal distribution are complex issues. You need a lot of time to go into them and to understand. You need a lot of historians often to understand these structural injustices, and is this framework where in a few years we're trying to find solutions and offer precise solutions and policy prescriptions. There's like a disjuncture between this deep historical understanding of things and trying to come out with recommendations in 2 years about things you can do. So I think that the field is structured in a way that makes it very difficult to accommodate those questions.
Yeah, I mean, I think that's right. I think that the sort of yes, there are real concerns, right, about, stability and regression that I think are, of course have been true in each of these contexts. But I do, again, sort of think that it does go to this question of how we label a particular place post-conflict or transitional, and exactly the timeline that is established by those labels. So once a place is transitional, then there's 2 to 5 years, and you're supposed to do these things, and we know which tools you use, and then you move on to your after transitional or after conflict or non-conflict or whatever, right? So there's a series of kind of categories that operate and that do work in terms of aid distribution and in terms of justice distribution and lots of other things. And so that, how the question of stability plays into that, right? When stability comes into play, how we talk about it in that particular moment, and who's mobilizing it are, again, they're contextual questions, but I think they're important ones in that regard.
Karen, did you have a question?
I did have a question. So maybe
and then we have some.
Now I sort of want to answer. So maybe I'll just, as a comment and a transitional comment, to say, in thinking about the compromises that take place at the moment of transition, I've been thinking about Colombia, and Rodrigo, if he's in here, can say more about it, but the extent to which there doesn't seem to be a sense of a need to compromise on the economic, right? And maybe the claims from the FARC haven't been so great on the economic side, but it just means it depends on where we're starting also, right, and what's happening at that moment of transition. But I had a question for Ali, and partly this is an apology for you being on a transitional justice panel, because the person on Colombia dropped out and we combined. So I wanted to let you talk a little bit more about your justice, your global socio-legal studies approach. And I just wanted to invite you to talk about the biocultural rights, and what's your intervention there, and how does it differ from the ways other people look at it?
Well, thank you. First off, with the global socio-legal approaches to human rights, what I really wanted to get to was that I think a big part of it is opening up the ontological and epistemological alternatives that are already happening in the world. We're just, and a lot of this, what I've been writing is kind of a reaction to a lot of critical scholars who are trying to rejuvenate the Marxist tradition within international law. And I see a lot of, even looking at yesterday, talking about a new international economic order. Yeah, I mean, I want that too. I'm also not holding out much hope that it's going to happen anytime soon, but that doesn't mean that we shouldn't start looking at what is happening or what is happening on the ground in different parts of the world, different social movements, how discourses of rights are being produced at certain levels and how they're traveling, circulating, the vernacular processes, and how, for example, I think Shannon Speed here at UT wrote a fantastic book about indigenous rights struggles with the Zapatistas, and how they were not victims of global rights discourses, but they took those discourses, appropriated them, combined them with local histories and epistemologies and understandings of rights, and their own cosmologies, and effectively reoriented those towards their own objectives. So, yeah, I mean, I guess what I'm getting a bit jaded with a lot of critical scholars who, although I laud their work and I love the devastating critiques, and I'm generally pessimistic myself, that doesn't mean that we shouldn't get into the nitty-gritty of social practices and things that are happening in places that might not necessarily line up to what we think of what the revolution will look like. You know, I think there are small revolutions happening all over the world, but we're just not studying them. I mean, critical international lawyers are not looking at these places. So that's kind of what I want to, you know, how I see, particularly with TWAIL, that's the kind of push I'd like to see within the movement, and have those people in conversation with legal anthropologists like Sally Engelmary and Mark Goodale and other folks like that. Now, looking at the biocultural stuff, I'm just starting to get into it. I'm not exactly sure what my intervention is yet. It sounds like a really nice, really good thing, and that inherently makes me skeptical of it. And I just, like I said, to me, on my first read of it, there seems to be a possible pitfall of essentializing indigenous peoples as stewards of the environment. And like I said, even in local struggles, communities can be pitted against each other in these types of issues, and who gets to have biocultural rights and this and that. So yeah, I mean, I think even, you know, sociological analyses of these types of issues can be really important, and just really how they're connected to, like I said, global legal processes that are happening at what we might consider to be very high scales. How are those norms traveling? How are those discourses traveling? How are the actual laws being, mutually constituted at different levels? I think that's kind of what I'm trying to get to, and with how I'd like to start to look at biocultural rights as I actually do decide what my intervention will be. So, thank you.
So we have, maybe if we take at this point a cluster of three questions and open it up. So there is somebody back here that had their. Oh, you have them. Okay, you have the
I have the microphone, so I'll take the floor. And I want to thank Natalie for asking for more historians. I'm one of them. So I guess my question has to do with if maybe we change to inequality and human rights to neoliberalism and human rights. That's really, it seems to me, what Ali's talking about, and I think she is as well. I'm reminded of what John Adams used to say about republicanism, which is it can mean everything, something, or nothing at all. And what exactly the historical relationship is between neoliberalism as a subject and human rights. Because it seems, I mean, you could argue, right, both emerged in the 1970s, but I'm not sure if the historical relationship between those two, moving from just one of coincidence to actual causality and complicity, perhaps, is really there. So I mean, this can maybe just for everyone. What do you all see as being the relationship between the emergence of neoliberalism and human rights? And is human rights even a language in a discourse that could affect inequality? Is it the best way of going about doing it, or perhaps do we need to look for alternatives behind a rights discourse to actually combat things like economic inequality?
Are there any other questions that want to? There's over here.
Thank you. I think as I listened to the talk about standards for international human rights, there seems to be an absence of discussion about structure. And I think there are structural levels and different elements to structure. For example, in sovereign states, we use law as a tool for peaceful social change, or at least we try to do so. Then we have failed states. Then we have emerging groups within that. I think we can't speak about everything in a cluster, but we have to look at the institutions, and we have to also look at them over time. I'm just curious how you react to that.
Is there a third question anybody wants to throw in before? Okay, well, I think, again, please, anybody who cares to respond to these provocative questions, go for it.
Do you want to start on the, should we go this way this time? Or?
Go red.
Okay. So to that first question, I think that's a very good question. What is the relationship between neoliberalism and human rights? And I think that first we have to think about what is neoliberalism? How do we conceive of neoliberalism? I think amongst international legal scholars, it's an economic program. Anthropologists are writing about it in much different ways. It's a cultural program. It's so much more than just economic, regulatory restructuring. Some anthropologists argue that it's actually opened up spaces for resistance that may have never been there before. So I think we have to get precise about how we want to look at neoliberalism, and it's not a monolithic thing, I think, which is what a lot of us tend to fall into the trap of. In terms of human rights discourses, like I said, I think what I'm interested in is seeing how they're being used, how they're being appropriated, and how they're being contested, and who's doing this and how. There's a really interesting book by Angelina Godoy who she looks at pharmaceuticals in Central America and the impacts of free trade and the discourses that are being used by groups there by different social movements there to contest the terms of free trade agreements that are imposing TRIPS plus agreements on access to medicines, and et cetera. And this is kind of where I get back to we need to really get close up and to begin to think about these questions. I just don't know how much value is left in kind of looking at it from a top-down perspective where we're using these really big concepts that are almost empty signifiers at this point.
On the question of the relationship between neoliberalism and human rights, obviously that's a huge question. Just a few thoughts. My sense is, for me, the relationship is not so much of causality, but rather of alignment. In particular, the way the human rights discourse has taken an individualized turn, right, from the 70s and more so now, envisioned as a way for the individual to challenge the state. That aligns very much so with neoliberal discourse, and I'll just give an example since I'm the micro person on the panel with the Marcos case. I asked a lot of the leaders of the ATS plaintiff organizations, do you have a dilemma here that you're trying to enforce your damage award and you would be removing funds from the agrarian reform program? And even the most, so the class is composed of many different groups, but even the most radical leftist groups, right, those who were underground guerrillas, who were Maoist, told me, the state can't do any redistribution. They're all corrupt. I don't trust the state. The most redistribution you can get is through us, by us getting some compensation. Then we'll use it in our families to start a business or to pay for education. So, of course, there's a lot of corruption in the Philippine government, or there was over the years that this was happening even within the PCGG of the Commission's own admission. But notice how those arguments align with a neoliberal agenda and of not placing faith in the state and not trying to reconstruct a collective space to do these projects. So on the other question that I think was addressed directly to me on whether there's a difference, I'm not sure I fully understand your question, if there's a difference between failed states and states in transition and more established democracies for the purposes of the argument. I'm sorry if you...
Yeah, and how you have to adjust your policy.
Yeah. Well, that's something, just very briefly, I'm struggling with, and I don't have any answers to. And if people in the audience afterwards want to talk about this, how, law is a generalized practice, right? It's abstract, and we want to say abstract. We don't want to break it down into all these little contexts. And a lot of the concerns that I'm raising here appear only in transitional contexts when there are scarce resources. So how do you design a human rights law? How do you think about remedies for human rights in a way that takes that kind of context into account, all the while still talking about general obligations and duties? I'm not sure how to do that. There are theories, there are models from administrative law maybe, or from environmental law, which sort of trigger remedial processes, but then the community has to figure out what to do. So there are directions, there are models we can look at. I don't know exactly what the solution is now, and I think it's a problem posed generally by this transitional justice framework as well. So happy to talk about it more with people during the break.
Maybe very, very briefly. We can. Well, we have 1 minute.
It's totally fine.
Okay, well, let's collectively thank the panelists and the audience.